I'm Faizan Shifi from Department of Electrical Electronics and Communication Engineering at the Indian Institute of Technology, Dharwad. So again, before we begin today's proceedings, I would like to take again a moment to express my heartfelt gratitude to my professor, Professor Rahul sir, for providing me this wonderful opportunity to deliver today's second talk on types of licenses in publication and literature, understanding different licensing options. So it's truly an honor to speak in front of such a vibrant and enthusiastic audience. So thank you, and let's deep dive into the topics for today. Okay, the outline of my today's discussion is going to be introduction to licensing, overview of different types of licensing, license elements, comparison of license types, choosing the right license, misconceptions and clarifications, hybrid models of license and publishing, and conclusion. So this is going to be the outline of my today's discussion. Okay, so let's begin with the introduction to licensing. So firstly, we will look for the definition of licensing. What licensing actually mean? A license is a legal agreement that grants permission to use, distribute, or modify the content. So actually, when you are having the license agreement, so you can then only you can grant the permission to use, distribute, or modify the content. So what is the purpose of this licensing? So it governs the usage, sharing, modification, and monetization of creative works. So importance of licensing in publication. What is the importance of licensing in publication? So it protects the creators' rights, specifies how the work can be used by others, helps in monetization and distribution. Why different licenses exist? So the other question is why different licenses exist. So it balances the creator rights with public access, facilitates academic collaboration, creative expression, and commercial use. So okay, so now overview of the different types of licenses. What are the different types of licenses? First one is the copyright license. Second one is the Creative Commons licenses. The third one is the public domain. Fourth one is the public access licenses. And the last one is the end user license agreements. Okay, so let's deep dive into the introduction to the copyright license. What is the definition of this copyright license? So copyright is nothing but it is a legal right that grants the creator of an original work exclusive rights to its use and distribution. It is designed to protect creators' intellectual property. So actually, when you are having the copyright licensing, so it is you have actually the legal right that grants the creator of an original work. So what is the importance in the digital age? So with the internet, content can be easily copied and shared if you are having the copyright license. So with the internet, content can be easily copied and shared, making copyright more important than ever in protecting creators. So this is the importance of this copyright licensing in the digital age. And you can see the diagram shown here. This is how we are going to represent this copyright license. Okay, now let's deep dive into the copyright license. The definition is copyright gives the creator exclusive rights to use, reproduce, and distribute their work. Rights of copyright owners is reproduction rights. Reproduction rights is focusing on digital reproduction in the era of widespread online sharing. And this other right is the distribution rights. Discusses how copyright owners control who can distribute physical and digital copies of their work and the implication of digital distributions of digital distribution platforms. So this is the second right, and the third one is public performance rights. So explains the importance of public performance rights in publication with examples of how these rights are licensed. So the fourth is the derivative works. So derivative works actually emphasizes more on the derivative, such as film adaptation of books or remixes of songs. So we are going to extract the derivative works. So it comes under this derivative work category, and how the copyright holders retain control over these adaptations. So other right is the moral rights. So explore moral rights, which protects the integrity and reputation of the author, and how these rights differ between countries. Okay, so now the key principles of copyright is, first one is the originality. Explore the meaning of originality in copyright law, emphasizing the necessity of the work being independently created and not copied. So it actually emphasizes on the originality of the work, that the work is produced by the someone that is the original, that has not been copied or independently created by other. So the other thing is the fixation. Discuss fixation in a tangible medium, which could include written text, digital recording, or even architectural plans. Okay, now the authorship and ownership. The key principle of the copyright is the authorship and ownership. It is more into the joint authorship and works created by employees explaining the complexities of determining ownership in collaborative efforts. So, what can be copyrighted? The other question is what can be copyright. One is the first thing is the literary works expand with examples of novels, poems, plays, and technical writings, emphasizing their protection under copyright. The second thing is we can copy the music and sound recordings. For example, you can copy the music itself, like musical composition, and the recording, some sound recordings you can copy. Okay, what are the software? And the third thing is software and databases. You can also copy software and databases. Explains how copyright protects both software source code and databases, detailing specific challenge in enforcement. Okay, the fourth thing is architectural works. It is actually more emphasis on the how it protects building design. Discusses in 1990 U.S. Architectural Works Copyright Protection Act. It discusses the Universal U.S. Architectural Works Copyright Protection Act and it how it protects building designs. Okay, now the important thing is the types of copyright infringements. First one is the direct infringements, which means explain what constitutes direct infringement, such as unauthorized downloading or copying of digital content. The second one is the contributory infringement, which means discusses contributory infringement, focusing on famous cases where the company was held liable for enabling users to infringe copyright. So these are the two, and the third one is willful versus unintentional infringement. That is explains it actually explains the difference between intentional copyright, what you have done intentionally, and the inadvertent violations, that is the unintentional infringement, with real world case studies. Okay, now what are the consequences of copyright infringements? So if you have copyrighted something, what are the consequences? First one is the civil penalties, in which discusses how copyright holders can sue for damages, including compensatory and punitive damages. And the second one is the criminal penalties for willful infringements. In this case, it comes under the detailed criminal penalties for large-scale commercial infringements, including fines and imprisonment of offenses like software piracy. Okay, now what are the types of copyright licenses? This is the most important thing. The first one is the exclusive license. Second one is the non-exclusive license. Third one is the sub-licensing. Fourth one is the perpetual license, and the fifth one is the term limited license. Okay, coming back to the exclusive license, where only one licensee has the right to use the work. In exclusive license, where only one licensee has the right to use the work, and discuss example in the film and publishing industries. For example, I have taken the examples of film and publishing industries over here. Okay, now coming back to the non-exclusive licenses, it is not inclined towards the only one licensee has the right. Multiple licensees will have the rights in this non-exclusive licenses, and it explains why creators may prefer to grant these in field like stock photography or music licensing. Okay, now the third thing is sub-licensing. Sub-licensing is where a licensee has the right to grant further licenses and provide examples for the technology and entertainment industries. Okay, so now the fourth one is perpetual license, where a licensee obtain indefinite rights to use the work, often used in software licensing. And the fifth one is the term limited license, where discusses how time limited licenses are common in industries like music and film, where rights revert to the licensor after a set period. Okay, now the comparison between different types of licenses, for example, exclusive versus non-exclusive. As I have already mentioned, this exclusive means only one licensee, while non-exclusive allows multiple people to license the work. And in sub-licensing, the licensee can grant additional licenses to others. And in perpetual versus term limited, perpetual license lasts forever, while term limited ones expire after a set time. So we are definitely going to discuss when this is going to set, when this is going to terminate. Now, coming back to the Creative Commons licenses, CC licenses, we are going to dive deep into this CC license in detail. So what is the overview of Creative Commons licenses? So it was actually a global movement to make creative work freely available under varying conditions. So developed by Creative Commons, it was to provide a standardized way for creators to share their work. So this in Creative Commons license, you are free to provide or standardize the way to share their work. So you are free to share your work in this Creative Commons licenses. So it allows creators to retain some rights while allowing for varying degrees for sharing and reuse. So what is the examples of uses? For example, academic research papers, educational content, or open data. These are the examples of these Creative Commons licenses. Okay, now there are 6 different types of Creative Commons licenses. So before touching upon those 6 different types of Creative Commons licenses, These licenses are designed so that the creator have options to provide restrictions of how they want their work to be used. But these 6 different types of licenses are made up of 4 license elements. Okay, so first one is the attribution by, as you can see the symbol, and the second one is the share alike, SA, and the third one is the non-commercial, and C, and the fourth one is the non-derivative. So when we are mixing these 4 elements, we're actually creating the 6 different types of licenses. So first one is, firstly, let us deep dive into the license element attribution by. So attribution means that anyone using the licensed work must give appropriate credit to the original creator. So here you are actually going to give the credit to the original creator who had produced the work. And again, the requirements are it users must attribute the creator in the manner specified by them, example by name, username, or organization. Typically, this involves mentioning the title of the work, the author's name, and providing a link to original work if available. So implications are this element is most permissive and appears in all Creative Commons licenses. It ensures that even if a work is shared, modified, or built upon, the original creator always receives credit for their contribution. So in this case, the implication is the original creator have always received the credit for their contributions. So the other is share alike license element. The definition is the share alike element requires that any derivative work, suppose adaptations, transformations, or modifications, must be distributed under the same or a compatible license as the original work. So this is the requirements for this share alike is if someone changes, suppose if someone changes, builds upon, or adapts the original work, the new work must be licensed under identical terms under the share alike license element. So for example, I have given the example over here. If a creator uses a work licensed as CC by SA, any derivative works must also be released under CC by SA. So if you are working with original derivative, you have to give the I can say you have to mention that as well. So here I have given the example. The implication is this element promotes the creation of open, freely accessible content that stays within the same license framework, ensuring that the future adaptations remain open for further use. So this is the implication of this share alike. So the third one is non-commercial. The non-commercial element restricts the use of the licensed work to non-commercial purposes only. So this is more inclined towards the non-commercial purposes. So the requirements are, suppose users cannot use the work for commercial purposes. Example, they cannot sell the work for or use it in any way intended for commercial advantage or monetary compensation. So implication is while users can share, remix, or build upon the work, they must ensure that the users does not involve any commercial transactions. So it is totally against the commercial transactions in this case. So if they want to use the work commercially, but there is a provision, if they want to use the work commercially, they must obtain separate permissions from the creator. Firstly, they have to take the permission from the creator. Only after that, they can use that for work for commercial purposes. So the fourth license element is the non-derivatives. So definition is the no derivatives element prohibits users for distributing modified versions of the licensed work. So the requirements are while users can copy, display, or share the work as long as they give proper attribution. So they are not allowed to alter, remix, or transform the work in any way in this non-derivatives. So the work must be distributed in its original form in this non-derivative licenses. Implications are this is most restrictive element as it prevents the creation of derivative work. So there is some restrictive elements which restricts this non-derivative license element. So users can only share in the exact original work without any changes. If they wish to modify the work, they have the provision to modify the work. So they must obtain separate permission from the creator. Okay, now different versions of you people might have across come with the different versions of the Creative Commons licenses. So Creative Commons licenses have gone through several versions before arriving at the current version 4.0. So the older versions was 1.0, 2.0, and 3.0, and still in use. So though 4.0 is now the most widely recommended and legally robust. So version 1.0 was released year was 2002. The key changes or features, I can say, it was the basic license structure focused on sharing. The limitations were limited international scope. This was the limitation of this 1.0. Release year was 2002. Now coming back to the version 2.0, the release year was 2004. The key changes of features, I can say the introduction of clearer terms, ported licenses, and the limitation was ambiguities in non-commercial definition. So there was some ambiguities in the non-commercial definition. Then to overcome the limitations of this version 2.0, then 2.5 version came in 2005. The release year was 2005. And the key features were minor improvements for usability and international use as compared to the 2.0. So the limitations here was also incremental changes, still no global scope. And then coming to the next version, it was 3.0, and the release year was 2007. So global porting, the key features was global porting, database rights, improved attribution. So limitations were continued ambiguities in non-commercial use. Okay, the 4.0 is 4.0, the 2013 and present. So this is what we are actually working today. So 4.0 Creative Commons 4.0, 2003, the release year was 2013, and it is working. We are working it present. It is working till now. So the key features are internationalized. So this is internationalized, clarified attribution, improved database rights. So the limitations are most comprehensive and flexible version. So the limitations of this 4.0 is most comprehensive and flexible version. So okay, so now coming back to the types of the Creative Commons license, that is one of the most important thing. So by combining these elements, these four elements, 6 Creative Commons license types are formed, each offering varied degrees of freedom. So first one is attribution license, CC BY. As you can see there, fig how you are going to see when there is some license, they are mentioning some licenses. And second one is the attribution share alike license, CC BY SA. So these licenses actually were formed by integrating those 4 license elements. So, and third one is the attribution non-derivatives licenses, CC BY ND, and the fourth one is the attribution non-commercial licenses, CC BY NC. And the fifth one is the attribution non-commercial share alike licenses, CC BY NCSA. And the last one and the sixth one is attribution non-commercial non-derivative license, CC BY NC ND. Okay, so now we are going to deep dive into the each of these licensing types one by one. So this is the general diagram of these types of the Creative Commons licenses, which I'm going to touch upon in the subsequent slides as well. So let's begin with the CC BY attribution license. So the CC BY license allows others to use, reuse, adapt, remix, and distribute the work for any purpose, including commercial use. So there is no restrictions in this CC BY. So the licensee, like the license allows others, you can reuse the work, adapt or remix, and distribute the work for any purpose, including commercial use. So there is no limitations in this case. So the only requirement is that the work or adaptation must be shared with attribution to the creator. The requirement, the work or adaptation must be shared with the attribution of to the creator. So the creator attribution should be there in this case. The applications are, for example, open educational resources, OER, scholarly articles. These are some of the applications of CC BY attribution license. Now coming back to the second case, CC BY SA attribution share alike license. So the CC BY SA license allows others to reuse, adapt, remix, and distribute the work for any purpose, including commercial use. So it can the difference between the CC BY SA and CC BY and CC BY SA is here the licensee allows others. It can others to reuse, adapt, remix, and distribute the work. So it requires attribution to the creator, and also that if you adapt the work and share, if you must share it, you must give your adaptation the same or a compatible license. So the applications are Wikipedia content, collaborative projects. So this is the application of this CC BY SA attribution share alike licenses. Now coming back to the third type of licenses, that is CC BY ND attribution non-derivative licenses. So the CC BY ND license allows others to reuse and distribute the work in an adapted form for any purpose, including commercial use. Adaptation are not allowed. So attribution to the works creator must be provided. So in case of the CC BY ND, the attribution to the works creator must be provided. The applications are published articles while modifications are not allowed. So this is you are not going to reuse and distribute the work. Okay, so in this CC BY ND attribution non-derivative license. So coming back to the fourth type, that is the CC BY NC attribution non-commercial license. So the CC BY NC license allows others to reuse, adapt, remix, and redistribute the work for any non-commercial purpose. Commercial use of the work is not allowed in this CC BY NC. So the attribution to the works creator must be provided in this case as well. And the applications are non-commercial blogs, personal websites, etc. So coming back to the fifth type, that is CC BY NC SA attribution non-commercial share alike license. The CC by NC SA license allows others to reuse, adapt, remix, and distribute the work for any non-commercial purpose. Commercial use of the work is not allowed in this case. So, in addition, if you adapt the work and share it, you must give your adaptation the same or compatible license. Attribution to the work's creator must be provided in this case. Okay, so applications are community-driven open projects, non-profit organizations. Okay, now coming back to the last type of this Creative Commons license, that is the CC by NC ND, attribution non-commercial non-derivative license. So the CC by NC ND license allows others to use and distribute the work in an unadapted form for non-commercial purposes. Neither commercial use or adaptation is allowed. So this is the last one, that is the CC. In this case, it allows others to use and distribute the work in an adapted form for non-commercial purposes. So neither commercial use or adaptation is allowed. So in this case, you are not going to use the license for the commercial purposes. So attribution to the works creator must be provided in this case as well. The applications are photographs, artworks, where derivatives are not desired. Okay, so here are some practical examples of Creative Commons licenses. First one is the Creative Commons in open educational resources like Wikipedia, music sharing, photography, and artworks. So the second example is CC license in different open source software developments. So why use Creative Commons license? The question is why we can use the Creative Commons license, and the answer is enhances content visibility and sharing. When you are using the Creative Commons licensing elements or Creative Commons licensing any thing from the Creative Commons license, so it actually enhances the content visibility and sharing, fosters collaborative and educational environments. So now coming back to the second type, there is the public domain. Public domain. Okay, so public domain dedication CC0 or public domain, I can say, aside from the 6 types of Creative Commons licenses, Creative Commons also provide a public domain to dedication tool, that is CC0, or I can say C/ copyright free, which is the way to relinquish all the copyright and mark one's work as being in the public domain. So the public domain consists of all the creative works to which no exclusive copyright or intellectual property rights apply. So CC0 includes a fallback licenses that allows anyone in the world to do anything with the work unconditionally. Okay. So coming back to the definition of this public domain, so the public domain CC0 or C/ refers to the works not protected by copyright, which can be freely used by anyone with permission. So here are, you can see at the right side, CC0 can be, there could be anything like CC0, no copyright, or public domain. These three, when you are going to see these 3 symbols, that means this is the work is in the public domain. So what are the common types of works in the public domain? So works whose copyright has expired. So I'm going to touch upon this in the subsequent slides when the copyright is expiring actually. So works that are ineligible for copyright protection, that also comes into the public domain later on, and the works that are voluntarily placed in the public domain by their creators. Okay, so how works enter the public domain? Though the important thing is how works enter the public domain. First thing is the copyright expiration. Okay, so once copyright protection ends, often the life of the author plus 70 years, the work enters the public domain. Okay, so actually in most countries, including the United States, European Union member states, Australia, and India, the copyright lasts for the author's lifetime plus an additional 70 years after their death. So this is then it enters actually into the public domain. But it varies, these cases vary from the copyright expiration, vary from the country to country, but the countries I have mentioned here is United States, European Union member states, Australia, and India. There these copyright actually enters after the 70 years, and after the death of the author. So now the second thing is ineligibility for copyright. Some works are never protected by copyright. Example, facts, government documents, or something that is easily available in the public domain. And the third thing is the voluntary dedication. Creators can choose to release their work in the public domain using tools like CC0 and others. Okay, now the historical works. Pre-modern works are often automatically in the public domain. So the pre-modern works are they are openly used in the public domain. So why the public domain matters? So why the people are talking much about the public domain? Okay, unrestricted access. So first thing is the unrestricted access. Public domain works can be freely used, reused, modified, and shared. So that is the why public domain matters. The one first thing is that. The second thing is cultural Preservation ensures historical and cultural works remain accessible to all. This is the second thing. And the third thing is innovation and creativity. Public domain content can be built upon inspiring new creations without legal barriers. The visual, what are the visuals for this public domain? You might have across come to the examples of famous public domain works by Shakespeare or Beethoven, etc. So these are going to be some of the public domain works. So okay, now the most important thing is public domain licensing tools. The two main tools provided by Creative Commons. One is CC0, Creative Commons 0, a license that allows creators to voluntarily waive all copyright related rights. And the second thing is public domain mark, PDM. You can see the symbols at the right side. A label indicating that a work is already in the public domain. No legal effect, is just informational. Okay. So what are the visuals when you are going to, the visual is when you are going to see the Creative Commons CC0 and public domain mark icon, so you can easily recognize it there. It is from the CC0 public domain mark Creative Commons. Okay, so CC0, now let's deep dive into the CC0 a bit more. CC0 is a legal tool that allows creators to waive all the copyright and related rights. So key features of the CC0 is no attribution required. Users can copy, modify, distribute, and use the work freely. Works under CC0 are globally applicable and irrevocable. Okay, so this irrevocable means unalterable. This works under CC0 are globally applicable and unalterable, we can say. Okay, so visuals is example of a work labeled with CC0. Okay, so now coming back to the public domain mark. Public domain mark is used to label works that are already in the public domain. Okay, so unlike CC0, it does not waive rights. It simply marks works that are not subjected to copyright. Okay, so commonly used by museums, libraries, and archives to identify historical and cultural works. So visuals are public domain mark symbol. When you are going to see this public domain symbol, so it definitely you can say that this public domain work, this is the public domain work. Okay, so now what are the features of this public domain mark? So first one is the labeling tool. PDM is public domain mark is not a legal license but a visual identifier. Okay, so used by institutions. So second one is the used by institutions. Many institutions use it to make works for public use, so that this is used by institutions as well, so that the work can be used publicly and freely. And no legal change. The third one is the no legal change. It does not alter the legal status of a work, just signals that it is in the public domain. Okay, so the most important feature of this public domain mark is no legal change. It does not alter the legal status of a work. So the legal status of the work remains same, and just signals that the work is in the public domain. So what are the visuals? Examples of an archive labeling works with the public domain mark. So this is the visual. Okay, now coming back to this comparison table between CC0 and public domain mark, that is one of the most important thing. Suppose the feature is type. Feature is type. So CC0 legal tool for waiving rights. So this CC0 is used for legal tool for waiving rights, and this public domain mark label to identify public domain works. Okay. Now the effects are, if we will talk about the future effect, this puts work in the public domain voluntarily and indicates in public domain mark case indicates that the work is already in public domain. Okay, now coming back to the future third, that is the attribution. CC0, it doesn't require any attribution, and similarly in the public domain mark, it also doesn't require any attribution as well. Now coming back to the future usage, this CC0 is open globally and irrevocable, unalterably used. So used by institutions to take this public domain marks is used by institutions to take public domain works. Okay. So, okay. Now coming back to the common use cases of CC0. First one is the open access research. Researchers use CC0, or you can see the symbol at the right of the screen, this CC0 to share data freely, ensuring that others can build upon their work. So the second common use is the open source software. Developers use CC0 to release software for unrestricted modification and distribution. And the third thing is the art and creative works. So artists use CC0 to share their work for free use and remixing. The visual is examples of projects using CC0, for example, research papers, artworks, or any other things. And the use cases for public domain mark, if we are talking about the use cases for the public domain mark, first one is the cultural heritage institutions, like libraries, museums, and archives use it to public domain mark to take works for public access. And the second one is the historical texts and art. Old books, suppose in this category, the old books, manuscripts, and the paintings are often marked to indicate they are free to use in this historical texts and arts. Okay, so the third thing is educational resources. That is important for this public domain mark and much widely used. So schools and universities may use the public domain mark to identify free, accessible, and accessible learning materials. So this is important in this education resources, where the schools and universities are using this public domain mark to identify free, accessible learning materials. So what are the visual examples of institutions using the PDM on their websites? So some institutions are still using their PDM on their websites. So what are the challenges and limitations of this public domain licensing? So there are certain challenges, and we're going to discuss them. First one is determining public domain status. Some works, especially older ones, may have unclear copyright status. So it becomes very hard to check whether they are in the public domain or not. So second one is the moral rights. So in certain jurisdictions, moral rights may still apply even after using the CC0. So this is other limitation for this public domain licensing. And the third one is the cultural concerns. Suppose traditional knowledge and cultural artifacts may face misuse if released into the public domain without considering community interests. So this could be the other limitation for this public domain licensing. Now coming back to the advantages and case studies of this public domain works. So firstly, it is freely available to all for any purpose. And second advantage is no restrictions on use, modification, or distribution. And the third one is the increases accessibility to cultural heritage. And the case studies, if we are talking about the case studies of public domain applications, so case study one is remixing Shakespeare's plays in modern literature. So I have taken some example from the this humanities field over here. And the second thing is use of public domain images in media and education. So these are the two case studies for this public domain applications. Okay, now the most important thing is open access licenses. So what is open access? And you can see the symbol over right side of the screen. This is the open access symbol, and open access refers to any unrestricted, we can say, online availability of scholarly research, data, and creative works. So any work can access, read, download, copy, distribute, and use these works without financial, legal, or technical barriers. So this is open access, where anyone can access and read, download, or copy and distribute their works without any financial, legal, or technical barriers. So open access actually helps us in advanced knowledge by removing access barriers in academic and creative fields. So what are the visuals of this open access? So suppose images or diagrams representing free access to research and knowledge globally. Okay, so importance, what are the importance of this open access? For example, democratization of knowledge. Open access makes research and creative works available to all, irrespective of financial or institutional access. So if you are having the access to the open access, so you can make use of it in a nice way, and you can use it freely. Okay, so increasing visibility and impact. Definitely, when you are publishing in the open access, then you might have the more citations and are cited more frequently and reach broader audiences as well. Okay, now the third thing is faster dissemination of research. Open access accelerates the spread of new findings, fostering faster scientific and societal progress. Okay, why use open access licenses? Why one should use benefits of this? I am going to talk upon this benefits of open access licenses. Why one should use this open access licenses? Okay, the first one is wider reach. The first benefit is wider. When the work is open accessly published, works published under the open access licenses are more likely to be read, shared, and cited. So this is the one of the obvious thing. And the second thing is promotes collaboration. When your work is in, we can say, in the open access domain, so you might get so many collaborators who are reading your work to get in touch with you for any further collaborations. So that is what I have mentioned. Researchers and creators can build on open access works, fostering greater innovations. And the third thing is maintenance author rights. While the work is free to use, creators retain copyright and control over the work is attributed. So the most important thing is cost efficiency. When the work is in open access, so it saves institutions, educators, and the public from costly journal subscription or paywalls. So definitely you don't have to subscribe anything, or you don't have to get the subscriptions to download or something, if I am talking about the research articles in this case. So it is the cost efficient. Okay, now what are the benefits for authors? So I am particularly talking about the authors. What are the benefits for the authors in this open access case? So open access provides authors with a worldwide audience. And the second thing is open access increases the visibility and impact of their work. And the third thing is open access widens opportunities for funding and international collaboration as well. Okay, so what are the benefits for students and professors? So open access gives students access to their research literature regardless of which institution they are based on. So this is when the work is in the open access, so you can use it freely, and the professors can more easily make available their own work for students to use. This is the benefit for the student and the professors as well in the case of this open access. So now coming back to the libraries, in the long term, open access may help alleviate the problem of increasing journal subscription costs. So open access helps libraries provide what their readers need. So when the work is open access, so libraries provide what they're actually demanding for, what their readers demanding for, and they can easily make it available for them. Now coming back to the third thing, open access helps libraries to work closely with authors and other parts of the university to make the research out more visible. So this is the other benefit of for the libraries using this open access work. Now coming back to the benefits of benefits for universities, increases the visibility and impact of the research being carried out in an institution. So this is going to definitely increase the visibility and impact of the research when the work is in the open access. Now coming back to the second part, that is the institutional repositories provide a showcase for a university research. And the third thing is open access is major tool in attracting new students and staff to a university. Definitely when you will see the open access articles generated from the staff or the university, so definitely it will attract the new students one or the other way as well. So coming back to the fourth part, that is the open access helps universities to share their knowledge and expertise. So this is the benefits for universities. Coming back to the benefits for funding agencies, open access increases the return on their investment in research by making the results of their research more widely available. Okay, so the second one is open access gives public access to the results of publicly funded research. The third thing is open access encourages faster developments and innovation in research. Now what is the benefits for government? Government open access offers government similar benefits to those experienced by funding agencies. In addition, open access promotes open democratic government by making information as freely as possible. Okay, now types of open access licenses, that is the most important thing. What are the types? First one is the gold open access, second one is the green open access, third one is the hybrid open access, and the fourth one is the diamond or platinum open access. So let's talk about this gold open access. In this gold open access, published articles are freely available online, often after paying an article processing charge APC to the publisher. So in this gold open access, the article APC has been already paid, so you are getting the open access article. You can download or freely use that article as well. If I'm talking about particularly talking about the research, these articles. So now coming back to the green open access, the second part, the second type, in this authors self-archive their preprints or postprints in repositories, in institution or subject-based, free to access, and they are free to access. Coming back to the hybrid open access, as the name itself suggested, subscription journals offer open access to individual articles for a free, while the rest of the journal remains behind a paywall. So it might be that some can use it for free and some have to pay in this hybrid open access case. Now coming back to the last fourth tab, that is the diamond platinum open access. So no fees for authors or readers, funded by institution grants or non-profit organizations. So you are going to download or use it freely. So there you don't have to pay anything in this diamond or platinum open access. Okay, so this is the process of these types of open access licensing. I have mentioned with the figure over here. This you have to pay the article processing charge, and then it goes for the open access publisher. Okay, now what are the legal considerations of open access licensing? So first one is the copyright retention. Authors often retain a copyright while using open access licenses to grant permissions to users. The second one is license enforcement. Users must adhere to the terms of the licenses such as attribution or non-commercial use. And the third thing is the license compatibility. ensure that derivative works comply with the original license. Example, using CC by SA means derivative must be also under the CC by SA. So this is the license compatibility in this case if I'm talking about the legal considerations of the open access licensing. So what the fourth thing is the moral rights. So in some jurisdictions, I have already mentioned moral rights. Example, right to attribution cannot be waived under open access licenses. So there are some conditions in the jurisdiction. So it vary from the country to the country. So now, what are the use cases of open access licensing? So first one is the academic journals. So many open access journals use CC by licenses to make their research freely available to the public. And the second thing is the educational resources. Open educational resources use open licenses to ensure learning materials are freely available. These are the two use cases of this open access licensing. And if I will talk about the third one, that is the government data. So governments increasingly use open access license to share public data for research, transparency, and innovations. Okay, so the fourth one is open science. So researchers release data sets, papers, and findings under open licenses to encourage collaboration and reproducibility. So what are the visuals of these use cases of the open access licenses? For example, examples of open access platforms like PubMed, Central Archive, OpenStack, or government open data portals. So you can see these are the open access licensing portals. So what are the challenges in open access licensing? Challenges and limitations of open access licensing. So first one is the funding for APCs. So it's sometimes it's very hard to pay the fundings for this open access because the article publication charges is usually to be very high. So this gold open access offer require authors to pay article publications charges. Sometimes when you are not able to make the fund from the outside organization, so you have to pay it from your own. So this is the one of the limitation or challenges for this funding of the APC for this open access. So the second one is non-compliance compliance by users, and that is not all users properly adhere to the license terms, such as failing to give attribution. And the third one is the institutional resistance. Some academic institutions and publishers resisted the open access movement due to concerns over financial sustainability. And what is the fourth one? That is the quality control. So some argue that open access journals may not have the same rigorous peer review processes as traditional journals. So what is the future of open access licensing? So one is the Plan S, or we can say the transformational policy. That is actually an initiative by several research funders that requiring that all funded research must be published in an open access journal or repositories. And the second one is the institutional support, shaping the landscape. So increasing support from universities, governments, and funding bodies to make open access the default for research publications. And the third one is the technological advancements enabling efficient access. So open access platforms and repositories are evolving, making sharing and archiving more accessible and efficient. The fourth one is the global collaboration and equity. So open access license is fostering greater collaboration among researchers globally, particularly by providing equitable access to knowledge in low and middle income countries. So now coming back to the other tab, that is the end user license agreements. Okay, EULA. So what is an end user license agreement? So EULA is we can say it is a legal contract between a software developer, licensor, and the user licensee that outlines the rights and restrictions for using the software. So on the basis of the mutual understanding, on the mutual convenience, they are developing a legal contract between the licensor and the licensee. So this specifies how the user can use, modify, and distribute the software, typically offering a non-exclusive licensee rather than ownership, where one or the multiple members can use the licensee. So it is very common in commercial software, apps, and digital services, this EULA. So the kind of legal agreement can go by different names. So we can call it by different names. Suppose sometimes we can call it a EULA or end use license agreement. We can call it license agreement, simply license agreement, software license agreement, or licensed application end user agreements. So what is the purpose of an EULA? First one is the protection for developers. So safeguards the intellectual property of the software developed. So this is the protection for the developer, first one. The second one is that defines usage terms. So specifies how the software can or cannot be used by end users. And the third one is the clarifies user rights. So ensures the user understands their rights, including restrictions on copying, modifying, or distributing the software. And what are the types of EULAs? So this is the important thing. There are the four different types of these EULAs. One is the shrink wrap license. Second one is the click wrap license. Third one is the browse wrap license, and the fourth one is cloud-based EULA. And firstly, let's deep dive into the shrink-based license. So it is the agreement that comes with the physical packaging of software. The user accepts the terms by opening the packaging. So actually it comes with the packaging and the user accepts it only after opening the packaging. The second one is the clip wrap license. So users must click I agree to accept terms before installing or accessing the software. So this is what we are usually looking for anyone who are downloading or installing the new software as well. So now coming back to the third thing, browse wrap license agreement available via a website where the act of using the software implies acceptance of the terms. So this third one is actually there the agreement available is available in the website where the act of using the software implies acceptance of the terms. Then and the second one is the close-based EULA, which governs access and use of a software as a service platform, often with recurring terms and updates. Okay, so grant of licenses, understanding the grant of license, it is the grant of license clause defines the user's rights, which are typically non-exclusive and non-transformable. So second thing is non-exclusive. Multiple users can use the software, but none have the exclusive rights. And the third one is the non-transformable. Non-transferable, users cannot transfer the license to another person without permission. So these are some of the understanding the grant of the licenses. And what is the scope of use? So scope of use, this section limits the use of the software to personal, commercial, or education purposes, and may define how many devices can run the software. So this is the scope of this grant of the licenses. So what is the restrictions on this EULA? So common restrictions in EULAs is reverse engineering, prohibited from decompiling or altering the software code. The second one is a copying distribution. Users cannot distribute copies of the software to third parties. And the third one is the modification. Users are generally forbidden from modifying or creating derivative works based on the software. And now coming back to the fourth thing, that is the use of software in unauthorized manner. So this restricts use in unlawful activities, including hacking or using the software in unapproved environments. Example, exceeding the user limits. So this is other restriction. Okay, now coming back to the intellectual property rights. So intellectual property clauses in EULEs are, first one is the ownership. The software and all the related IP, including patents, trademarks, and copyrights, remain with the developer or licensor. And the second one is non-transfer of ownership, purchasing the software, grant of license to use it, but does not transfer ownership of the software itself. The third one is the third-party IP, that is acknowledges that use of third-party software components, example, open source libraries that may be subjected to additional terms. Okay, now coming back to the comparison of these license types. So firstly, let's take this copyright. So what are the rights reserved? Yeah, all rights are reserved in this case. Permitted uses limited to specific permissions. Restrictions, strict limitations. Examples are books, movies. Now coming to the Creative Commons, varies by type. Rights reserved are varies by type. Permitted uses are educational, non-commercial use, and the restrictions are varies from one case to another case. And the examples are images, or we can say blogs. Now coming back to the third license type, that is the public domain. Rights reserved none. So permitted use are restricted, and the restrictions are none. This is free from the restrictions, and the examples are classic literature. Now coming back to this open access, some rights are reserved, and this permitted uses, research, academic use, and the restrictions are publisher dependent. This is more inclined towards the publisher dependent thing, and the examples are scientific papers. Now coming back to the EUL end user license agreement, this rights reserved are developer specific, and the permitted use are software use. Restrictions are usage restrictions, and the examples of software tools. So this is the comparison of all the license table we had discussed in the previous slides. So now coming back to the hybrid model of licensing and publication. So as the name itself indicates that there is some integration between this licensing and publishing. So we are going to deep dive into it. So firstly, let us define what is this definition of hybrid model. So hybrid models refer to publishing systems that combine both traditional subscription-based access and open access. It is more like that when somebody is giving the we can say the presentation, he can give a presentation online and offline as well. So integrating both the things. So it is like the same way hybrid models refer to publishing systems that combine both traditional subscription-based access and open access. In these models, certain articles are available for free under open access license, often after payment of APC, while other remains behind a paywall. So it is, suppose some institutions are making some articles free to use for their students, and but for the other institutions, they have to pay to access to that article. So it is like that. So coming back to the examples, so journals like IEEE, Nature Communications, and Springer Open offer hybrid options, where authors can choose to make their research open access by paying APCs or opt for traditional publishing. Oh, okay. Now the growing trend of hybrid journals is hybrid journals have becoming a popular way for traditional publishers to transition towards open access, and these journals allow authors to select between open access and traditional models, offering more flexibility, but at the cost of higher APCs. Okay, other thing is the criticism. Critics argue that hybrid models perpetuate double dipping, where publishers charge both subscription fee to libraries and APCs to authors, raising concerns over the ethical implications of profit-driven publishing models. So this is the criticism for this hybrid models of licensing and publishing. So other thing is Creative Commons in hybrid models. So hybrid journals often use Creative Commons licenses, example CC BY, for open access articles, allowing authors to retain copyright while enabling others to freely access and use the content with attribution. So these hybrid journals often use Creative Commons licenses, and it vary, and it is freely accessed and used to the content with attributions. So examples here are the journal IEEE Nature allows authors to choose from different licensing options, including Creative Commons licenses when making their articles open access. Now the new licensing models, the third thing is new licensing models. As hybrid models gain traction, new forms of licensing are being explored that accommodate both commercial interests and the principle of open access. For example, embargoed access allows content to be freely available after a set time period, while retaining some commercial rights for a limited duration. So it is something new licensing models have introduced. So impact on publishing ecosystem. So hybrid models offer a stepping stone for traditional publishers to engage with the open access movement, but they also complicate the landscape by maintaining barriers for certain works while promoting free access for others. So this is some impact on the publishing ecosystem, because they are also complicated to landscape by maintaining barriers for certain works while promoting free access for others. So it may be free for some people and not free for the others. So the case studies here is Elsewhere's hybrid journals. Elsevier has become a major player in hybrid publishing, offering a portfolio of journals that allows authors to pay for open access or opt for traditional paywall models. So there you can publish both things, either open access that can be freely available for the readers, and or you can publish that as behind the paywall models. So however, the publishers have faced backlash for its high APCs. It is one of the limitations for this open access, as we have already mentioned in the previous slides as well. This too much APCs is becoming sometimes very hard for a author to pay, and the subscription fees leading to the boycotts from the academic community. This is the one of the case study for this hybrid models as well. So now coming back to the conclusion of this today's discussion regarding this licensing. The recap of the key points is understanding the types of license is crucial for creators and users. Each license type serves different purposes and needs. And final thoughts are like choose the license that best aligns with your goals of for your work. For example, if you can opt for the open access, you are having the funding agencies, or you can pay you can choose that. Otherwise, you have the other options as well. So the other thing is stay informed about licensing trends and updates. So this is one of the most important thing, because sometimes these are changing continuously regarding the vary from the journal to journal, if I am talking about the research journals. So this is all from my side. Thank you.